The legal landscape has fundamentally changed. The Economic Crime and Corporate Transparency Act 2023, ECCTA, empowers the SRA with unprecedented fining capabilities, demanding immediate attention from every legal professional. This is not merely an update, it is a critical re-evaluation of ethical responsibility and compliance, where ignorance is no longer a defense. The ECCTA 2023 grants the SRA unlimited fining powers for economic crime breaches, a stark departure from the previous £25,000 cap. This applies universally to solicitors, law firms, and their staff, encompassing offences like fraud, money laundering, and sanctions violations. A new failure to prevent fraud offence for large organizations mandates robust, demonstrable compliance systems. For all legal professionals, especially SQE1/FLK1 candidates, understanding these expanded powers is paramount. Your ethical duties, integrity, transparency, cooperation with regulators, and proactive risk management are now under intensified scrutiny. This legislation underscores a professional obligation to uphold the highest standards. The SRA's enhanced enforcement capabilities mean that every decision carries significant weight. Firms must implement and rigorously maintain reasonable procedures to prevent fraud, as strict liability applies. This necessitates comprehensive training, continuous monitoring, and a culture of unwavering ethical adherence. For students, this means integrating a deep understanding of economic crime and compliance into your foundational knowledge. For practitioners, it demands a proactive review of internal controls and risk assessments. The stakes are reputational ruin, unlimited financial penalties, and the potential loss of your professional standing. Recent cases highlight the SRA's resolute stance. SRA v. Husain, 2025, demonstrates zero tolerance for conduct undermining public trust. SRA v. Dentons UK, 2025, confirms that even inadvertent AML breaches constitute professional misconduct. These rulings are not isolated incidents, they are clear signals of the new enforcement paradigm. The Simpson Thacher, 2025, £300,000 fine for AML failures foreshadows the scale of penalties now possible. These cases serve as critical educational tools, illustrating the tangible consequences of non-compliance and the absolute necessity of ethical vigilance. The ECCTA 2023 is a game-changer, demanding a heightened sense of urgency and professionalism. Unlimited SRA fines are a reality, and robust compliance systems are your primary defense. Ethical conduct, transparency, and full cooperation with regulators are no longer optional but fundamental requirements for practice. Act now. Review your firm's compliance protocols, educate your teams, and ensure your personal ethical compass is unyielding. For students, embed these principles into your learning. The future of your profession and your career depends on your proactive engagement with these critical changes.